I have been called many things from the bench biased. Cold, too strict, too blunt, too old-fashioned. People say all kinds of things when the evidence stops helping them and accountability starts moving closer. But I will never forget the woman who looked me in the eye in my own courtroom and called me unqualified. Right before I read all 19 violations attached to her name. Her name was Karen Holloway. And from the moment she entered my courtroom, she carried herself like the rules were written for everyone except her. She wore a pale gray blazer, glossy heels, and carried a thick folder under her arm. Not a folder of evidence, a folder of complaints. I could tell before she opened it. Some people bring documents to explain the truth. Others bring paper to create smoke. Karen brought smoke. Across from her stood Daniel Brooks, a city permit inspector with tired eyes and a calm face. He looked like a man who had spent months being insulted for simply doing his job. His hands were folded in front of him, and he did not look angry. That mattered. Anger performs. Exhaustion remembers. The case appeared simple on paper. Karen claimed Daniel had unfairly targeted her property renovation, delayed her permits, embarrassed her in front of contractors, and caused her financial loss. She wanted damages, apology letters, and an order forcing the city to stop harassing her. Daniel's response was brief: 19 code violations. That was it, 19. When I saw that number, I looked up because 1 or 2 violations can be confusion. 3 or 4 can be poor planning. But 19 tells a different story. It tells you someone was warned. Repeatedly. I asked Karen to explain her complaint. She stood immediately, as if she had been waiting for her spotlight. "Your Honor," she said, "this inspector is abusing his position. He clearly doesn't understand how real property development works." Daniel did not react. Karen continued, "Frankly, I'm not even sure this court is qualified to understand it either." The gallery went silent. That was the first moment the room felt the shift, not because I was offended. Judges hear insults. The robe teaches you not to chase every foolish word thrown at it. What interested me was why she said it. She was testing the room. People like Karen often begin with disrespect to see if authority will retreat. If no one corrects them, they move further. If someone does correct them, they call themselves victims. I looked at her calmly and said, "Mrs. Holloway, this court understands permits, evidence, and the consequences of ignoring lawful notices." Continue. Her smile tightened. She had expected a reaction. She got procedure. And procedure is a very difficult thing to bully. Karen claimed she was renovating a small rental property on Oak Ridge Avenue. She said the work was minor, cosmetic. Paint, cabinets, flooring, landscaping. But Daniel's face changed slightly when she said minor. Only slightly. I saw it. Then Karen said, "Mr. Brooks walked onto my property like he owned it and started inventing violations. I asked Daniel if he had documentation. He nodded." Karen laughed, a short, dismissive laugh. "Of course he does," she said. "People like him hide behind paperwork." That sentence told me everything, because in court, paperwork is not hiding. Paperwork is how memory becomes accountable. Daniel opened his folder slowly. Karen's eyes moved toward it. And for the first time since she entered, her confidence looked less like strength and more like fear that someone had finally counted everything. When Daniel Brooks opened his folder, Karen Holloway's expression changed. Not enough for the gallery to notice, but enough for me. Her eyes followed his hands. Her smile faded at the corners. Her fingers tightened around her own folder like she could somehow hold the truth back by gripping paper harder. I have seen that look many times. It is the look of someone who is not afraid of being misunderstood. They are afraid of being documented. Daniel began calmly. He explained that the city had received 3 separate complaints about Karen's renovation property. Noise after permitted hours, construction debris blocking the sidewalk, and workers entering through an unsecured rear gate beside a neighboring home. Karen rolled her eyes. Daniel continued anyway. That impressed me. There is a quiet professionalism in people who refuse to match disrespect with emotion. He submitted the first notice. Expired permit approval. The second, unlicensed electrical work. The third, plumbing alterations without inspection, Karen interrupted. Those are technicalities. I looked at her. Technicalities are often what keep houses from burning down. The courtroom became still. Because that is the part people forget about permits. They are not decorations. They are not paperwork for the sake of paperwork. They exist because bad wiring kills people. Bad plumbing creates damage. Unsafe structures collapse on families who never knew shortcuts were taken behind the walls. Daniel submitted photographs next. Exposed wiring, open trenches, a removed support beam. Piles of broken tile blocking the public sidewalk. Karen said that beam wasn't important. Daniel finally looked at her. For the first time, anger appeared behind his calm. It was load-bearing, he said. The gallery reacted softly. Karen looked away, and there it was again. Not confusion, not a mistake, but arrogance being cornered by facts. I asked Karen if she had hired licensed contractors. She said, I hired experienced people. That was not the same answer. I asked again, licensed? She hesitated, then said, some of them. In a courtroom, those little phrases matter. They are where truth leaks through. Daniel then explained that Karen had been given multiple chances to pause work and correct the violations. She ignored the notices. She covered exposed areas before inspection. She continued construction after a stop work order. Karen snapped, because every delay costs money. I said, so does repairing illegal work. That landed harder than she expected. Her face tightened again. Then Daniel submitted a copy of the stop work order. It had been posted on the front door, photographed, emailed, and mailed. Karen claimed she never saw it. Daniel turned a page. He had a photo of Karen standing in front of that same door, holding the notice in her hand. The courtroom shifted. Karen said, that doesn't prove I read it. And in that moment, I understood exactly what kind of case this was. Karen was not denying facts because they were false. She was denying responsibility because she believed responsibility required her permission. Then Daniel said, Your Honor, by the time we inspected again, there were 19 violations. 19, the number hung over the courtroom. Karen laughed again, but it sounded weaker now. She said, and I suppose you expect this court to understand all 19. I looked at her. I do. Her smile vanished. Daniel handed me the full violation list, and as I began reading the first page, Karen looked suddenly aware that insulting the court had not made the list disappear. I began reading the violations one by one, not quickly, not angrily, carefully, because when a person dismisses 19 violations as harassment, the courtroom deserves to hear exactly what that person is asking everyone to ignore. Violation 1, work performed under an expired permit. Violation 2, electrical wiring installed without licensed supervision. Violation 3, plumbing changes completed without inspection. Violation 4, construction debris blocking a public sidewalk. Karen shifted in her seat. Violation 5, removal of a load-bearing beam without structural approval. The gallery went silent. That one had weight, because everyone in that room understood the difference between ugly renovation work and dangerous renovation work. A bad paint job embarrasses a homeowner. A missing support beam can injure someone. I looked at Karen. She would not meet my eyes. Daniel Brooks stood calmly, but I could see the exhaustion in his face. He had not created this list to win a personal argument. He had created it because the law required him to document what he saw. That is what Karen had called harassment documentation, I continued. Violation 6, exposed wiring left accessible. Violation 7, no approved waste disposal container. Violation 8, unpermitted rear deck framing. Violation 9, improper ventilation modifications. Karen suddenly interrupted. This is ridiculous. I looked at her. No, Mrs. Holloway, this is the record. That stopped her for a moment, but only for a moment. She said, you're just reading whatever he gave you. There it was again. When facts become painful, attack the person reading them. I said, and you will have an opportunity to respond to each one with evidence. She opened her mouth, then closed it, because anger is not evidence. A folder full of complaints is not evidence. Confidence is not evidence. Daniel then submitted photographs matching each numbered violation. The screen showed image after image. Exposed wires near insulation. A trench filled with standing water. A staircase missing guardrails. Workers cutting into framing without protective supports. The room grew heavier with every photograph. Farron's minor cosmetic renovation was disappearing in real time. And something far more dangerous was taking its place. I asked Karen, did tenants live in this property during any of this work? She hesitated. Daniel looked down. That hesitation told me the answer before she said it. One tenant was still moving out, Karen replied. Daniel corrected her calmly. A family was living in the rear unit for 11 days after the stop work order. The courtroom reacted. Karen snapped. They knew construction was happening. I leaned forward. Did they know a load-bearing beam had been removed without approval? She did not answer. That silence mattered, because the case was no longer just about permits. It was about risk. It was about a property owner treating safety rules like personal insults, while other people lived inside the consequences. Then Daniel produced emails from that tenant, Olivia Parker, a young mother with 2 children. She had complained about sparks from an outlet, dust coming through vents, and workers leaving tools near the back entrance. Karen had responded to one email with, "If you don't like renovations, buy your own house." The courtroom went cold. I looked at Karen. For the first time, her confidence looked ugly, even to herself. Then Daniel said, "Your Honor, there is video from the second inspection." Karen's face changed completely, and I knew the violation list had only opened the door. The real truth was about to walk through it. The second inspection video began with Daniel Brooks standing outside Karen Holloway's rental property. The stop work notice was still taped to the front door. Clear, visible, impossible to miss. Then the camera moved toward the side of the house, where construction noise could already be heard from inside. That was the first problem. A stop work order means exactly what it says. Stop, not slow down, not continue quietly. Not finish one more section before anyone notices stop. Daniel knocked on the door. No one answered. Then the camera showed workers exiting through the rear gate carrying pieces of lumber and electrical supplies. Karen had told the court work had stopped. The video showed otherwise. I looked at Karen. She stared at the screen, her face tight, her lips pressed together. The video continued. Daniel asked one worker who authorized the continued work. The worker hesitated and said, "The owner said inspectors are just making noise." The gallery murmured. Karen snapped. That worker misunderstood. But the video was not done. A few seconds later, Karen appeared in the frame, pawn in one hand, coffee cup in the other. She looked at Daniel and said, "You again? Don't you people have real crimes to deal with?" Daniel stayed calm. "Mom, this property is under a stop work order." Karen laughed. "I don't recognize your authority." That sentence filled the courtroom like a warning bell, because people who say they do not recognize lawful authority are often really saying they do not recognize consequences. Daniel explained the violations again. He pointed to exposed wiring near the rear entrance. He pointed to debris blocking the walkway. He pointed to the open wall where structural support had been removed. Karen interrupted him in the video and said, "You're not qualified to tell me how to manage my investment." Then, on the screen, she looked directly at Daniel's camera and said, "And neither is the judge who ends up hearing this." The courtroom turned toward her. That was the moment everyone understood her insult in court had not been spontaneous. It was part of a pattern. She had decided long before the hearing that anyone enforcing rules against her was unqualified. Inspectors, tenants, judges, anyone. I asked Karen, "Did you say that during the inspection?" She said quietly, "I was frustrated. Frustration. Another word people use when arrogance gets recorded." Then Daniel submitted the tenant's video. Olivia Parker had recorded from inside the rear unit. Her 2 children could be heard coughing in the background. Dust floated through the air. A plastic sheet covered part of the hallway, but did not seal anything properly. Olivia's voice was shaky as she said, "There are wires showing near the kitchen, and my kids are scared to go outside because workers keep leaving boards with nails by the stairs." Karen looked away, and for the first time, I saw Daniel's composure almost break, not because Karen insulted him, because children had lived inside the danger she dismissed as technicalities. I asked Daniel if the rear unit had been cleared after that complaint. He nodded. "Only after emergency enforcement, Your Honor." Emergency enforcement. That phrase changed the weight of the case. Then Daniel handed over the final inspection packet. He said, "The 19 violations are only the confirmed ones. There were additional concerns still under review." Karen whispered, "This is harassment." But nobody believed her now. The screen still showed the dusty hallway, the children coughing, the exposed wires, the stop work notice on the door. And when Daniel reached for one final photograph, Karen suddenly stood and said, "That picture is private." The courtroom went completely silent because no one had said what the picture showed. But Karen already knew. When Karen Holloway stood and said, "That picture is private," the entire courtroom understood something before the photograph ever appeared. She recognized it, and recognition in court can be louder than confession. I asked her calmly, "Mrs. Holloway, how do you know what photograph Mr. Brooks is about to present?" She froze. For the first time that day, she had no insult ready, no accusation, no speech about harassment, no comment about qualifications, only silence. Daniel Brooks handed the photograph to the bailiff, and when it appeared on the screen, the courtroom changed. It showed the basement utility room of Karen's rental property. Inside were loose electrical lines hanging near a leaking pipe. Stacks of flammable construction material pressed against the wall, and a space heater plugged into an overloaded extension cord. But that was not the worst part. In the corner of the image was a small mattress, a child's blanket, a backpack, a pair of tiny sneakers. The gallery went completely still. I looked at Karen. She would not look at the screen. Daniel said quietly, "Your Honor, during emergency enforcement, we discovered one of the tenant's children had been sleeping in that room because the renovation blocked access to the second bedroom." For a moment, even I struggled to stay composed. Because permits can sound boring until you see the life sitting inside the violation. A child had been sleeping beside exposed wiring and construction debris while Karen called the rules technicalities. Olivia Parker, the tenant, was called to speak. She walked forward slowly, holding tissue in one hand. Her voice shook as she explained that Karen had told her the renovation would take 2 days maximum. Instead, walls stayed open, workers came and went, dust filled the unit, and one bedroom became unusable. She said, "I asked if we could stay somewhere else until it was safe." Karen interrupted. I offered options. Olivia turned toward her, tears in her eyes. "You told me to sleep in my car if I was that dramatic." The courtroom erupted. I struck the bench once, and silence returned, but the damage had been done. Karen's face turned